Morning, everyone. This time of year tends to be a very busy one for recruitment. People are often acting on their New Year's resolutions to finally find that new job, and businesses are often entering new financial years with a budget to increase headcount, or at least know where they stand for their headcount for the year ahead. And even people who are waiting for bonus payment day, typically in the financial services sector, just have to wait till February or March payday, and then they can be free to resign as well. So all that makes for kind of a perfect mix of a fair amount of kind of movement in the market between now and kind of the summer lull period. So over the next kind of 3 to 4 months tends to be quite a bit of movement. And so we thought it would be quite a timely moment to look at recruitment generally, and to take a look at some of the kind of practical aspects of recruitment, albeit from with an employment law kind of angle to them. So we're going to kind of walk through the recruitment process and look at some of the key points to consider at each stage. But first of all, why does it kind of getting recruitment right really matter? Well, apart from the obvious, when we're all operating, or most of us operating in a kind of a service sector industries, and so we're not really making anything, but we're making our money by selling our people. If we don't kind of have good people, obviously we're not going to do very well. But it also matters from an employment law perspective, because recruitment is an area which contains a lot of pitfalls for the unwary, particularly in terms of discrimination risk. So risk of unlawful discrimination and risk of claims arising from that. For those of you who don't know, job applicants are protected from under the discrimination laws in the Equality Act in the same way people who are actually in posts are already protected. So you're protected from discrimination even when you just submit an application form. And the Equality Act makes this very clear, that you're protected in terms of the arrangements that the company makes in terms of the recruitment process followed, the terms on which employment is offered, so financial terms and general kind of package, and finally you're protected as an individual in respect of the decision whether or not to offer you employment in the first place. So all that means it's worth considering how to minimise that risk kind of throughout the process, and what you can do to minimise the risk of those claims. So if we take a look at right at the very beginning of the kind of process, when you're at the early preparatory stages of looking to recruit, in addition to any internal paperwork you may be needing to complete, you'll typically need to come up with the job description for the role and the person specification. Now, the job description is essentially why the job exists. Why does a business have this role? And typically that doesn't actually need to be very, very long, kind of a paragraph or two at the most. It's really saying how that role fits into the business and why it actually exists. The second document, the person specification, tends to be a fair bit more detailed, setting out the experience, the skills, essentially the expertise, the type of person you're looking for in terms of their ability and their behaviour and kind of character traits and so on. I think it's important when you're looking at that is to really draw a distinction between what's essential and what's desirable, and ask yourself, are all these so-called requirements we're setting out here actually necessary for the job we're trying to recruit for? Or by inserting them, having them as requirements, are we actually going to be narrowing the pool unnecessarily and potentially missing out on some good talent, or perhaps incurring some discrimination risk in terms of the diversity of the applicants we're looking at? We were actually advising a barrister's chambers recently, and they were looking to recruit a new business development director on a kind of fairly senior position on a fairly significant financial package. And in terms of their person specification, they had listed, they sent it to us for our review, they said, oh, must have a 2-1 degree or better. And we said, well, presumably the person you're looking to recruit is probably going to have 15, 20, maybe 30 years of experience. So they may well be in their kind of 40s or 50s. Is it really relevant that they got a degree when they were 21? And actually, if it is, does it really matter what the degree was? And I think sometimes it's worth doing a bit of devil's advocate on your own kind of so-called requirements and asking yourself, do we actually need this, or are we going to be limiting ourselves in some way? And I think that can come into play in a kind of a lesser degree in terms of how you describe certain qualifications you may need outside, of course. Some industries and professions will have certain professional qualifications, but just in terms of saying, GCSEs or A-levels, obviously some people may have studied or either at a different time or in a different country where those qualifications weren't relevant. So it's important to kind of preface those with, GCSEs or equivalent or something along those lines. Assuming you've done all your kind of groundwork and you're ready to kind of move forward with the kind of the advertising stage, from a discrimination point of view, you want to be considering, well, how do we attract the kind of the best pool of talent and the broadest pool of talent? And I think often organisations understandably want to be trying to save recruitment costs, and so they look at first for internal recommendations, so recommendations from existing staff. I mean, we certainly do that here at Fox Williams. We have a kind of referral scheme, and we look to our lawyers and staff for recommendations of their friends at other firms in the hope that we can save the recruitment fees. But that should only ever form part of the selection pool. You should always be casting your net more broadly if you want to try and attract the best talent out there. Otherwise, you're fishing in really quite a small pond. And from a kind of diversity point of view, often you end up attracting people similar to your existing staff. If you're advertising for position internally, then whatever you do, please don't forget those people who aren't actually in the office at the time, particularly those on extended leave, such as maternity leave and long-term sickness absence. Now, the long-term sickness absence point may be less of an issue in practice because they may well not be able to take up the job anytime soon. But the maternity leave point does actually see quite a few organisations getting unstuck. We've helped quite a few employers with difficulties in that regard because they haven't drawn internal vacancies to the attention of people on maternity leave, and sometimes even people who are due to return very soon. And so these individuals have missed out on opportunities for promotion as a result and have sought to kind of bring claims or at least grievances on the back of that. And so it's important to consider those. And actually, although you may be thinking, well, they can't actually start the job immediately, and tribunals not actually going to view it in that same way, that they'll be viewing it as should they have been offered the chance to apply for that job. And then when you're considering advertising, if you haven't been advertising that recently, I think it's worth considering is the forum you advertised before still relevant? Things are moving on quite quickly, and actually the kind of tried and tested approach that you did 2 or 3 years ago may not be the best way going forward, and that's where specialist recruitment agents can really come in to guide you. And I think finally, in terms of the wording of the advert, it's important to be wary of the kind of the vexatious litigant, the people who have far too much time on their hands and spend a lot of it looking at job applications, trying to spot the kind of discriminatory criteria or wording in there. You just want to avoid that hassle from someone saying, well, I've been discriminated against because of the wording on your advert. I could have done the job, but you've asked for something that I can't do because of my personal, I'm disabled or something like that. The people who are prone to doing those have actually been dealt quite a blow last year, thankfully, because there was a European case which really echoed various English law authorities, which said that an individual is only protected as a job applicant if they're a genuine job applicant, so if they're actually applying with a view to getting that job. Now, in that case, I think it was a German case that went to the European Court, the individual was simply trying to make a living out of applying for all sorts of different jobs and had absolutely no intention of applying for that job. So I think that gives us as employers some comfort. Assuming you're now then kind of at the application stage, risk of stating the obvious, it makes sense to have a fairly standard approach so you ensure everyone's competing on a level playing field, whether that's CV and covering letter or an application form. You want to make sure you have a consistent approach across the board, and also to be prepared to make reasonable adjustments when individuals raise that issue with you. Now, this is an important point because the duty to make reasonable adjustments in a kind of recruitment context isn't anticipatory in nature. So you don't have to, for example, think, oh, well, someone who's visually impaired may apply for the role. We need to make sure our hard copy form or our online form is compatible with whatever software technology the individual may be using on their computer. So you don't have to try to cater for every circumstance in advance. But when someone does raise an issue as part of the application in terms of seeking an adjustment to it, then you do need to be prepared to consider it. And if that's going to take you a bit of time, then one adjustment you may need to make is actually to allow the individual a bit more time before cutting off the deadline for applications. And then, of course, you need to be careful what to do with personal information that you gather as part of the recruitment process. Now, most organisations have a mechanism for separating out personal data to the extent that they ask for it for purposes of equal opportunities monitoring. So they typically are able to kind of carve out personal information in terms of religion, sexual orientation, and disability, and so on. But you need to make sure you've got that mechanism. I think one important point to note is actually if you do separate it out and have that system in place, and it's not referable to an individual's name, then that actually ceases to be personal data if the individual can't be identified from it. So assuming you've got your applications and you're now at the shortlisting stage, there can often be a tendency to check out individuals' profiles on social media, and I know David's going to be talking about this in just a moment. I'd urge some degree of caution though in doing that. Although kind of nosiness or curiosity may mean you want to take a look, it's important to be careful with the information you do find, because you should only be considering information that's relevant to the individual's role. So if you discover, for example, they've been arrested or convicted for something, then obviously you may find out that through a different means, but obviously that may be relevant to the role you're hiring for. But if, say, you discover they're a member of, say, an evangelical Christian church, well, that's really probably got nothing to do with the underlying role. So you shouldn't be thinking, oh, we just want them to do the job. We don't want them trying to convert all our staff or get them to go off to their church. Really, what people do in their personal lives should be viewed as irrelevant if it's of no consequence to the actual role, and particularly if it's relevant to a protected characteristic, their religion or their sexual orientation and so on. But assuming you've got the applications and you're looking to kind of carry out an objective shortlisting exercise, the best way of doing this is obviously to have criteria based on the underlying job description and, more importantly, on the person specification you've come up with, and to have a very clear framework for scoring those individuals. And that's incredibly important when there's actually more than one. It's important generally, but particularly where there's more than one individual who's going to be carrying out the assessment exercise. So here at Fox Williams, we receive several hundred applications for our training contract places every year and have just a handful of jobs to offer. And so because of the sheer volume of applications we receive, there's about a dozen of us who help filter in the kind of a first wave of applications. We're given very clear guidance, a very clear framework on how to score those in each question in the application process. So, for example, they're all scored from 0 to 4, 4 being the highest mark. And we're given very clear guidance on what type of answer would merit a 1, what would merit a 2, and so on. So ensure that everyone's assessed as objectively and as uniformly as possible. You may also want to consider some sort of kind of weighting criteria, if some criteria are more important than others. But when you've gone through all the process, you obviously need to decide who's going to be shortlisted. You may have a minimum score, for example, 70 out of 100 perhaps, but if that generates too many people to be practical to go forward, you may then want to just take the top 10, 20 or top 10 or 20% from those. And that takes us neatly on to the interview stage. Now, we touched on reasonable adjustments in terms of the application earlier, but when it comes to interviewing people, you should be asking individuals when inviting them for interview if they do need any adjustments to be made when they attend the interview. I mean, obviously you kind of typically think about physical adjustments, but from time to time there may be other adjustments to make. Whoever's doing the interviews, and we'd always recommend a kind of a panel approach. That doesn't mean a huge, long, intimidating panel, but 2 individuals rather than 1. Needs to have had some training in equal opportunities matters, and ideally in the context of recruitment. And that the same point applies actually equally to anyone who's been involved in the shortlisting or the kind of the filtering process before we get to the interview stage. For those of you who've had the unfortunate incident of kind of being on the receiving end of a tribunal claim and actually have had to be cross-examined in a tribunal hearing that's gone the full distance, you'll know that one of the questions that tribunal panels love to ask in discrimination cases is what training you've had. And really it's a real own goal if you haven't actually had any training and you're defending a discrimination case. And typically if you get to that stage of having proceedings brought against you or against your employer, it's too late to then be arranging it, because obviously you want to be showing that you'd already had that training at the time. going back to a point about having a kind of a level playing field and a uniform approach, really you want to be asking all individuals the same questions and to be keeping a kind of note of their answers, or at least a kind of brief note of their answers. And of course, risk of stating the kind of blindingly obvious, steering clear of any questions about their personal circumstances, their domestic situation at all. I think sometimes people often end up straying into that because I think it's trying to build up some kind of rapport with the individual, or some kind of a small talk. But I think sometimes that can backfire. So I think it's best to save that type of conversation for when the individual's actually been offered the job. Taking us neatly on to the subject of offering jobs. I think when you get to the offer stage, you want to be making the job offer conditional on various pre-employment checks. And I'll come on to what checks you might want to consider in just a moment. But what you don't want to be doing is making an offer that the individual can just unilaterally accept without any kind of strings attached to it. And on that subject, I think it's worth having in every employment contract what's called an entire agreement clause. And this is one of those kind of unglamorous clauses which is typically kind of buried near the back of a contract with other kind of boilerplate type provisions. But it's actually a very important one, because essentially what it's saying is that this contract contains all the terms relevant to your employment. And so essentially anything that's been promised in the interview process or perhaps by email as part of the negotiations doesn't count for anything unless it's actually in the contract. Because as an employee, you want to know where you stand. You want everything to be in there. And sometimes that's backed up or complemented by wording along the lines that they haven't been induced to enter into this contract, enter into the contract by any representation made in the interview process which isn't set out in the contract. In terms of taking a cautious approach, I think it's also worth making the individuals confirm or warrant that they're not aware that they won't be breaching any existing contract when they join you, or by doing the job in question. And by this I'm particularly thinking about any non-compete provisions or any post-termination restrictions which may either prevent them from joining you straight away, or when they do join you actually limiting what they can do, what they can do for you, at least in the first few months. Simply by asking the question at this early stage, you typically flush out if there are any issues, and then at least you can consider in conjunction with the individual how best to handle them, and avoid the risk of being at the receiving end of a claim from their former employer for inducing a breach of their contract. So turning now to the pre-employment checks I mentioned earlier, I think the single most important one, I know my immigration colleagues here will agree with me, checking the individual has the right to work in the UK and the role in question is probably the most important one, not least because of the financial penalties involved of not doing so, but also because of the reputational consequences of failing to do that. And it should be done uniformly for every single person, regardless of whether you know the fact that they're British and they have a British passport. You should be carrying out the same checks for everyone, asking to see their underlying documents, so their underlying passport and so on. References, I think, form part and parcel of pretty much all pre-employment checks. Though I think in practice they're often of limited value now. Most, certainly kind of larger organisations do what we call kind of tombstone references of just name, job title and dates of employment. They're useful for verifying that information. Sometimes the references, particularly if they're from a smaller employer, go beyond that. And so I think it's important to make clear that the references should be satisfactory to you. So it's not just conditional on getting references, but it's conditional on whatever they say being satisfactory. So that, for example, their dates of employment stacking up with what they've been told. And in terms of that kind of verification process, you may also want to verify other background information, such as their academic or professional qualifications, by asking to see their underlying certificates and so on. And for certain roles, you may want people to go through health checks or to go through a kind of a health MOT, typically with a totally separate provider. It really depends on the nature of the role, whether you want to be asking for that. As you probably know, you shouldn't be asking for any health-related information prior to the offer stage, unless you can really show it's critical for the role in question, or you need to ask for it in the context I mentioned earlier, namely asking about reasonable adjustments during the interview process. Then finally, depending on the nature of the role, there may be some need to carry out criminal records checks via the Disclosure and Barring Service, what used to be called the Criminal Records Bureau, or through one of the agencies that kind of works with them. That's very much going to depend on the role, whether you want to be asking that, and indeed the nature of the role will also dictate the level of information you can get. In most roles, individuals are entitled not to disclose convictions which have been spent. So that takes us on to a kind of closing comment, really, but a comment which kind of pervades each of the different stages of a process, and that's really the importance of record keeping and keeping records kind of throughout the process. So not just the job description and person specification, but how you actually score people in terms of scoring them against the selection criteria, and then in turn records of the interview process in your decision on that. Because really, ultimately, what you want to be showing is showing that you've taken all reasonable steps to avoid any discrimination or unlawful harassment during the interview process. And that's consistent with what the Equality and Human Rights Commission Code in relation to employment recommends, that you keep that paper record to show that you've, to justify the process you followed and put yourself in a good position of defending any claims if you're on the unfortunate receiving end of one. There's obviously a balance there to be struck though, because you don't want to be keeping information forever. You've also got on the other side the kind of contention of your Data Protection Act obligations, and obviously the obligation under the Data Protection Act not to keep personal information for longer than necessary. I think the period of time you want to retain information is really going to turn on the nature of a role in your timeline for recruiting. But I would have thought a rule of thumb of about 6 months is probably appropriate, because by 6 months, in most cases, you'll know whether an individual is going to bring a claim, because they'll have had to trigger the ACAS early conciliation process by then, or have actually filed a claim. That's very much kind of a rule of thumb, though, and shouldn't be kind of set in stone, because it will depend on your recruitment time frame and when you actually offered the individuals jobs as well. On the flip side, you want to be careful to encourage individuals not to create an unhelpful paper trail, and that's really where the training piece comes in, to make individuals aware of how things can come back to bite them. I was talking with a colleague last week, and they were saying at their old firm they had a client who rather unhelpfully had written annotations, kind of scribbled comments at the top of their interview notes to try to help them remember who each individual was. That was fine if it just said, kind of tall chap with glasses, but unfortunately in some of them it said black guy with glasses, and that obviously, when they were on the receiving end of a claim from a disgruntled job applicant, looked like the individual's colour was taken into account in the recruitment process. If you do have disgruntled or just curious unsuccessful applicants asking why they haven't got the job, the tendency can be to not give them any information, but I think sometimes that just fuels the fire. And from a discrimination point of view, it's a bit like firing someone and not giving any reason. You create a vacuum in which they can effectively allege discrimination. So I think you're always best off giving a reason, or at least an explanation. I think so if people do ask for feedback, then you should give to the extent that it's feasible. I mean, obviously, if you've got thousands of applications, it's a different matter. But if it's practical to give feedback, and I think if you can give brief feedback based on how you assessed them against the underlying person specification and how they stacked up against rivals, then I think that makes sense. And that's certainly consistent with what the Equality and Human Rights Commission Code says to do. Often, if individuals are given an explanation that actually, they had good skills, but there were other people who had more relevant industry experience, perhaps, then that would be, that helps satisfy their interest or their curiosity. Finally, and obviously ending with the inevitable plug, if in doubt, take advice. Getting recruitment wrong can be very expensive, because discrimination claims can be expensive. And even if there's not significant financial liability at stake, they can be very expensive to defend, and very expensive in terms of time as well to manage. So with that, I will now hand over to David, who's going to talk about social media in the workplace. Thank you.